Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Elyse Dorsey, and the title of today's episode is What About Small Tech? User Data and Privacy in Blockchain-Based Projects and the Future of the Internet. Web3 is being touted as the future of the Internet. The vision for this new version of the web revolves around the notion of decentralization, driven by blockchain-based technologies like cryptocurrencies and NFTs. User privacy is central to these advances, but what does all of this mean for decentralized finance compliance and identity verification? How does a small tech company navigate the overlapping web of privacy, competition, and other regulations? And what are the implications for user data access? In this episode, we'll explore these burgeoning horizons as we speak with Matt McGuire, General Counsel of Violet, about all things Web3, crypto, and privacy, including what's happening with California Privacy Agency's CPRA implementation. Joining me today is my co-host, Jana Seidl. Hey, Jana.
Hey, Elyse.
Would you like to introduce our guest?
I'd be happy to. As you mentioned, Matt McGuire is General Counsel of Violet. Violet is a compliance and identity solution provider. Matt has a diverse legal background. He's worked in big law, the government, and in-house previously, so that gives him incredible insight into the blockchain regulatory landscape through a variety of different lenses. And on top of that, as you'll hear, Matt is clearly passionate about Violet's mission to evolve trust in Web3 through compliance and identity infrastructure. Welcome, Matt.
Thanks, Jana. Thanks, Elyse. I'm very excited to be here and talk about Violet and Web3 and crypto, all things I care a lot about.
Awesome. Yeah,
Thanks
we're
for
very
joining us.
We're very happy to have you today. This is a bit of some new territory for our podcast, so we're looking forward to it.
That's wonderful. I think from my perspective, the more the merrier as we talk about crypto and Web3 and all of the awesome possibilities it opens up for everyone.
Yeah, and with that, you mentioned Web3 a couple of times, and I know we threw that term around. Could you give us a quick overview of what Web3 is and what makes it so different from the traditional web that we're also used to, just to kind of orient our listeners?
Yeah, for sure. I'll give a quick overview of my view of Web3. I think as you talk to people in the industry, everyone has a slightly different view on what that term means, and it can pack a lot in there. And feel free at any point to ask me to explain other things I might throw out in jargon. I tried to get better about using it, but I'm not the best. But Web3 essentially looks at what the internet is as it's sprung forward out of the tech boom and sort of the large platforms that have been created, and especially the way data is handled, and says, well, what if we re-envisioned the whole archetype of how we hand out data on the internet and like really centralize users as the core point of the technology? So instead of sort of thinking about it from an advertising perspective, that everyone can follow you around and they have giant warehouses of data about you that maybe you did or didn't ask them to create or give them permission to use it for a specific reason. What Web3 says is you own your own data. User privacy sits at the core of it. And sort of the view is that instead of an internet of a few major companies controlling things, every user sort of stands alone as their own decentralized version. And you tell people what you want to tell them about yourself. And that's what attracted me to the space. And sort of to Violet in particular is this idea of, wouldn't it be better if you really had control over your own personal identity and the world on the internet, just like you do when you go out in public? You sort of decide who gets to see you, you decide where you go, you sort of have some control over what people know about you. And it strikes me that the same ought to be true on the internet. So Web3 is sort of a conglomerate term that packs in all of the technology underneath it and re-envisions how we could approach life online.
So just, a small minor project for the internet, huh?
Yeah, no, nothing like a wholesale overhaul to the entire way the world has reorganized itself. And I get that reaction a lot, which makes me laugh, because if you think about it, the Web 2 version of the world is actually quite new, right? I mean, it's no more than 20, 30 years old. And there's no reason why it has to remain that way. And we're sort of at an inflection point, I think, for whether we want it to just be that way. We like the way society is organized now online, or do we want to have space for these other innovative approaches for people who care about these topics?
Yeah, I think those are some really great questions, and kind of come up a lot in our podcast and like in the space with antitrust and privacy and data security, where we're on the forefront. It's an inflection point for a lot of things for all of these regulatory agencies as well. So it kind of seems like maybe a perfect storm here.
Yeah, no one really knows what to do about it. And it fits kind of awkwardly into existing rules because it comes at problems from a sort of completely different angle. So it feels the same in some ways as what's currently out there, but it actually works in a very, very different way. And in some ways, it's been out in public long before all of the use cases have developed. So people form very strong views on crypto and Web3, which I'm happy to debunk some of them. But I do think the industry has come a long way from where people started to hear about it around 2012.
Yeah, so that's really exciting. So can you tell us a little bit how Violet fits into that and where the idea is to go forward in the future?
Yeah, so I'm biased as the general counsel of Violet, but I left Shopify where I was beforehand because I was just thrilled with the possibilities around what Violet is doing. So Violet sits at this core infrastructure piece of Web3, sort of focused on two things: identity online and compliance. And I'm very excited to say that we just launched one of our first sort of product tech demo sort of things called human-bound tokens, which is Violet's take on identity management. The idea being you can come in and get an NFT from us that discloses no personal information about you on the blockchain. And the blockchain is just the series of blocks that everyone can see, which builds trust in the ecosystem. You can see every transaction all by sort of hexadecimal keys. And it looks like gibberish if you just go pull it up. But what Violet can do is issue a credential that says that gibberish is actually Elyse or Jana or Matt. And we can then screen against what we know about you to send any type of compliance signal that you may want to send. But the real core awesome part about human-bound tokens to me is no one gets to know anything about you that you don't want them to know. So you get all the safety and security that you get from sort of traditional compliance. It depends on knowing a lot about people without actually compromising your privacy. And that to me has been really awesome to see. I am super excited. I think most people think of crypto as having a couple of major coins. They think of it as Ethereum or Bitcoin. But I think it's more useful, at least for this conversation, to think of it in terms of blockchains, which makes it ever more confusing. But there are all sorts of different layers of blockchains in the world. Violet's focused on the Ethereum blockchain because of the smart contract ability. This idea that you can write things programmatically in code that self-execute. So all the lawyers out there, you write a contract, you have all kinds of provisions. Someone has to interpret them. What my engineers would come behind and say is, well, what if you could write that in code? So a bunch of machines can read it and self-implement a lot of key terms. And that's what Ethereum allows you to do. And we've now launched our token on 4 different blockchains across Ethereum, which gives us a wide range of ecosystem use cases. The idea being no matter where you want to build or do something, you have access to an identity solution that will work for you and really protect your privacy as a core value.
Yeah, well, speaking of privacy, California is, kind of at the forefront of privacy regulations. And we know Violet recently submitted some comments to the California Privacy Protection Agency regarding its rules and implementation. And your perspective, we think, was that the agency didn't go quite far enough in its proposal. Is that right?
That's true, which is a fun position for me to be as a lawyer to say, really, we could do even more to protect people's privacy online than what even some of the most ardent privacy advocates would come out and argue for. And that is, in a sense, the beauty of the way Web3 works, because you can achieve more privacy when you're logging in with a wallet. And so before I explain our privacy rulemaking comments, let me explain the wallet a bit just so that it makes more sense. But when you connect natively in Web3, you sign it with that random set of numbers that's assigned to you. So that's all anyone ever necessarily needs to know is I click the connect wallet button and I've showed up and I'm just a set of numeric digits. And that key piece of it means that you can live with a whole bunch of privacy regulation because you're not monetizing people's data. It doesn't depend on knowing anything about the user. The whole ecosystem works blind. So from our perspective, it's like, okay, you can take a lot of actions to restrict data usage. We don't monetize data in Web3. It's yours. It's committed to you. And you come up with business models that work around it. The one real sticking point that comes up a lot is government access to data, though. So what you end up saying is, okay, it's okay to regulate private businesses and avoid their use of data in certain ways. And that's a lot of what privacy regulators are doing, whether it's GDPR in Europe, whether it's this CPPA, now the agency in California. They're focused on limits on companies' use of your data, sort of for purposes that you didn't say they could use it for. What Violet came in and said is, well, that's all fine and dandy, but what you should do is hold the government to the same standard. There is no reason that we should sort of, especially as Americans, be allowing mass surveillance sort of in odd ways under the Fourth Amendment, just because other people, other private businesses have aggregated lots of data on you. Right. So we filed comments to sort of flag this to California of you should hold your own agencies to this standard. If they want to know something about me or anyone listening, they ought to get a subpoena. It ought to be jurisdictionally valid. They ought to follow all the rules that exist in the law that we all learn in law school. Because the reality is that's not how it works in most cases. A lot of companies hand over information voluntarily. There's an expectation from government actors that you will provide it very quickly without making them jump through all of these hoops. And you can get some pretty threatening encounters where they'll look to come investigate you if you're not meeting those expectations. And we flagged some other things that I think are troubling, sort of the mass purchases of data by the federal government and some agencies, sort of IRS-related subpoenas that have always bothered me, this idea that a few people may be committing tax fraud, so you can demand an entirety customer list from an entity so that you can go check if all of their customers are meeting their tax obligations. And we just don't think that there's any place for that.
It's one of the criticisms, right, that of, kind of Bitcoin or earlier iterations, right, that they were essentially lawless and, what can the government do about it? But I think, to your point, there might be better, more strategic, more deliberate ways for government agencies to approach this holistically, right? Not just, from the business side, but from their side as well to, help everyone understand what the rules are and, how to follow them and how to protect people's privacy.
Yeah, I mean, I'll use a word that everyone uses too much, which is trust. But I've always viewed it as bidirectional trust. Right. And that's sort of what makes my job fun right now is it's talking to the community in Web3 of you have to live with the government for some reasons. We don't want bad actors. You don't want money laundering. You need to shed this view that crypto is lawless and that every single person who touches it is subject to some kind of bad act or another at one point in time. We have to move past that, which requires some amount of compliance. The inverse is true. To move past it, you have to be able to trust the government, that they're acting in good faith, that they are pursuing bad actors, that they care about people's privacy, that it isn't sort of this lawless, warrantless surveillance state. And until you can sort of bridge the gap and everyone is trying to act in good faith and playing by a set of rules that everyone understands and accepts, you won't get very far.
No, that's definitely something to keep thinking about, especially as we're looking at the kind of patchwork of privacy regulation, right? Elyse had mentioned how California is kind of at the forefront, but other states are moving forward as well. And then we're still in this world where there is no federal privacy law. So how can you talk to us about some of the challenges of having the state-by-state fragmentation of privacy law for a company like Violet or other companies and how to kind of navigate through that?
Yeah, it's really, really challenging. So I can sort of speak to it from both kind of a true, from one of the bigger tech companies' mindsets and sort of from the Web3 perspective. Having a patchwork of laws is almost impossible to comply with. So I've spent a lot of my career looking at international laws and conflicts of laws that arise there. It's the same is true at the state level here now with the privacy framework. And what you're left with as a company, regardless of industry, regardless of what you do, is where those laws apply, you have to pick the most burdensome and just sort of apply that across the board. Because unless you can sort of silo data technically, right, people throw around the word in the privacy space, a lot of data localization, which means a bunch of different things depending on what exactly you're talking about. But even technically speaking, it's very expensive, if not impossible, to silo things by server in exactly the jurisdiction that has exactly that law and impose exactly those protections on it. I think it's why, candidly, you saw so many companies just apply the general data protection regulation globally, because that was the lowest common denominator coming out of the EU. It covered 90-something% of the requirements in other locations. And then you adapt the most critical sort of idiosyncratic pieces of other laws. Like if you go pull a standard privacy policy, you will see a bunch of riders that say for Nevada residents X, for California residents Y, probably pretty soon Colorado residents Z, Virginia, pick one. And it just winds up being a mess. And then it's very hard to actually implement that from the company perspective. So I think it's helpful actually to hear that and have empathy for companies. Most try to do the right thing in my experience. No one's trying to violate these laws, but it's very hard technically to actually set it up and achieve true compliance. I know the FTC is currently looking at a data privacy rulemaking. I think comments may be due next week. And then the federal legislation in Congress has been moving along. But there's a lot of debates about preemption there. I think that has become one of the main sticking points, especially out of California, is will federal privacy regulation preempt California law? And that being a major driver for whether that legislation succeeds.
And, coming from your background where, you've worked at, not a huge tech, but, bigger tech company and now are, kind of at a smaller startup, what are your thoughts on preemption and how that would play out and maybe how it differentially impacts firms based on their size and capabilities?
Yeah, I think it's actually really important, especially for smaller companies, right? You don't have the size and scale of a legal team to go vet 50 different laws and think through exactly how you could thread your product through all of them in a way that would work. So having one standard set of rules that apply helps tremendously. And I think that's actually even true of the largest companies because, you want people to comply with the law. It's not supposed to be a game of gotcha. So you have to have some actual path through it, whatever that happens to be. So I think the preemption makes a great deal of sense when you're talking about systems that aren't even just national to the US. These are international systems, right? The way the internet works, it's very hard to balkanize it and say, this is our US pool, this is our European pool. Products and services do move cross-border and funds flow all over the place now. So I do think having at least a national standard in the US that says this is the barometer. If you hit this, you're fine. And then it preempts other laws makes sense. You can conceptualize that, though, in a bunch of different ways, right? Take the securities laws. You still have tons of state securities laws out there, but there are specific preemptive carve-outs if you go through the SEC and follow certain rules that would exempt you from some of those blue sky laws. So you can take a bunch of different approaches.
Yeah. And kind of on that point, what are you seeing in terms of, government action here in this space against, maybe smaller companies, maybe some of the bigger ones? What are you seeing though?
It's a hot time for enforcement in the crypto world. I think as anyone who follows this space has probably seen in the news, there seems to be a new enforcement action and a new theory of liability about every 6 hours in the moment. You could spend days just trying to unpack what everyone's doing. You've seen enforcement actions recently out of the SEC in the US. You've seen enforcement actions out of the state attorneys general. You've seen an enforcement action out of the CFTC. And I think it's actually maybe useful to spend a couple of minutes just worth talking about some of this because it just has a crippling effect on innovation in a way that I'm not sure is always apparent. And none of this is really making the market any safer. If the idea behind most laws is compliance helps protect investors or certain rules help protect consumers, you would expect the enforcement actions and the agency dynamic to match that. But that's candidly not really what I have seen. The SEC has taken a bunch of really aggressive positions. It's no secret the chair has said repeatedly that in his view, everything in crypto is a security subject to their jurisdiction. I don't think that's a point of view that can possibly match reality when you look at what all the tokens do, frankly. There's just so much diversity in how crypto works and what the individual tokens represent on chain that they're not all securities. And I just don't think the Howey test can be understood as saying anyone who chooses to speculate on something renders that thing a security. Right. We don't think of wine as a security, and plenty of people collect all kinds of fancy bottles of wine that appreciate in value over time. Right. So that is a flaw in that piece of it. But then there's also been just weird enforcement actions that are worth noting. There was an insider trading case filed criminally out of the Department of Justice, where the SEC also filed a tag-along civil action, where the claims in the complaint are that all of these tokens are securities. But because it arose in a criminal proceeding, none of those companies who suddenly get named and said that all their tokens are securities had a chance to defend themselves. They're suddenly in a criminal lawsuit that will make precedent on what their tokens are without actually clear due process to defend the issue. So that's very messy. And then I can say more about the CFTC piece, but I'll stop in case you want to chat any more about the SEC.
No, that's definitely really interesting to hear. And, it begs the question of whether or not this goes back to the attitude of, look, there is this lawlessness about crypto, right? And how we need to change perspective and approach, which might then in turn influence enforcement action again. So maybe this is just one way of trying to ensure that there is at least an avenue to go after whatever there's out there.
Yeah, I think that's 100% true. And
they understand the flip side of, go ahead, Matt.
Yeah, I think that's completely true. I mean, I think if you talk sort of to government enforcement actors, they're responding to a problem that has been a long time coming, which is you can't meet anyone who's been in crypto since the mid 2010s, so 2014 on, who hasn't suffered some kind of fraud or another at one point in time. Everyone will have a story about some kind of like bad actor who took advantage of somebody. And I think we all know enough from our government experiences to know that that's just not something the government enforcement actors will accept or live with, and they shouldn't. Like, fully agree on that point. But the cases they're bringing aren't always targeted to those actors. Like, some of these tokens are like power utility tokens or carbon offset tokens. Like, there's no demonstrable harm there. These things haven't committed any type of fraud, and there's no real notice coming with the claims. Now, I think the most frustrating piece to me, at least on the SEC side, has been this invitation to come in and talk and find a path forward. It's like, find a way to actually register, find a way to operate an exchange, find a way to issue tokens in compliance with the law. But I think most industry insiders would tell you that you can't actually do it. If you go in and talk, you might wind up investigated. You won't get your license. Things just don't materialize right now. So you sort of are paralyzed in the current moment as a good actor. And that's a little bit on the CFTC side, why their case is really interesting. And there's probably no one who's a service of process nerd out there. But if there are, it is a case that is made for your heart. The CFTC suddenly brought a claim targeting an unincorporated group of individuals. To throw one more crypto acronym out there, you have what are called decentralized autonomous organizations, or DAOs, as people are probably may have heard of them. From a law school perspective, you can think of them as sort of a random group of people who organize on the internet to sort of pursue some business aim or another, which, I think in fairness to the CFTC, you think that's pretty much joint and several liability under black letter law. This is why corporate governance rules exist, is to avoid this exact situation. But the theory behind DAOs has been that they're not subject to the rules that way, that there's such a loose affiliation there that it's not really even an unincorporated association. The CFTC suddenly came out with a settlement and a complaint saying, we've settled with the founders of this protocol, which will just stipulate said stuff they shouldn't have said, that they decentralized to avoid regulation, did stuff improperly. And they settled with the founders, but then they filed a complaint against every member of the community who held the tokens and had ever voted them in the governance proposals, seeking the same types of relief against these otherwise anonymous people. And it was really interesting from a service piece of it, because they tried to serve the DAO through the chat box on their website. And they filed a motion for alternative service saying they posted it in a forum and served it through this chat box and said that that should be sufficient to constitute service on the entire DAO. At this, for the litigation people, like, it's really interesting because the judge granted it. And right after the judge granted it, you had two sort of crypto associations, more or less, file amicus briefs saying, like, hey, you shouldn't grant this. This is not proper service. This is not how these things work. There's all kinds of causation problems here. Like, you don't even know if anyone who voted a token saw the chat box. And there's just completely missing all these allegations. But as we all know, an amicus has no standing to do anything in a case. Things say stuff, but there's no party. The judge sua sponte reopened it and has ordered additional briefing from the government, is now going to take oral argument, I believe, at the end of November on service this way, in response to a couple of amicus briefs, which I found really interesting, because if the judge thought nothing was there, I don't think they would have done anything.
Yeah, no, I'm with you. As a full-on litigation nerd, I totally will be following that. I'm glad you flagged it.
Yeah, I mean, how often do you see a motion for reconsideration granted over service?
Right.
Yeah, and that's like in a really creative and actually kind of interesting and not just super arcane, boring legal mumbo jumbo kind of way.
Well, and you can go look up the graphic for this DAO. That'll make your day. It's called Ooki DAO, OOKI, and it's got a cute little figure that represents it. It's adorable.
Awesome. Well, I look forward to that. I think we're getting about close to the end of our time here today, but I did, before we get quite to the end, want to touch base on some antitrust issues just very briefly. We spent a lot of time talking about the privacy issues today, but when we were prepping for this session, I know we also covered a lot of antitrust ground as well. I think one of the things was on interoperability. You mentioned at the outset that Violet's kind of building off of Ethereum right now. And right now, there's, I think, a lot of interoperation. Is that necessary to Web3 going forward? Do you see any concerns? Should antitrust regulators be concerned? Thoughts and feelings?
Yeah, I see Web3 to me is going to be the Wild West for antitrust lawyers. And I hope everyone starts to look at it, right? Because you could look at it each tier. Once you start to understand the tech stack and you sort of see points of centralization in all kinds of odd places, and people talk to each other in those pieces of the tech stack in ways that may or may not raise other concerns over time. But to answer the question directly, I think interoperability is huge. I can't say it's like a foundational principle necessarily to Web3. I think like every industry, you have varying degrees of wanting to interoperate. But currently Web3 is built very much in an open source tech stack mindset, which sort of leads everyone's project to build off each other, and things typically are rewarded for the actual value they generate for the ecosystem versus sort of a capture, which comes out pretty great. So I think we should continue to encourage it. And I hope that the community continues to follow it. But at the same time, I wonder long term, like how much choice anyone gets. If you sort of look at what has come out of the European Union with the Digital Markets Act and some of the aggressive interoperability requirements on sort of gatekeeper power, I feel like you see, at least to me, you're more of an antitrust expert than I am, but you see this concept of intentional lack of interoperability or intentional gatekeeping showing up more and more and more in competition cases. And I think it will be good for everyone in Web3 to keep that in mind as you sort of structure your projects and build. Now, I say all that, there are silos, right? Like if your program works on Ethereum, it won't work on Solana. You'd have to go rewrite the whole thing. They use different programming languages. There's no easy ability to transport between sort of, I'm going to use another term, core level 1 blockchains. And you can think of those as just like the transmission lines that run past your house. These are supposed to be the baseline infrastructure that everything is built off of.
Great. Well, I think maybe we'll just leave that there for now as a little teaser for next time. That sound good to you, Jana?
Absolutely. I think with that, we will dive into some of the getting to know you questions, Matt, that we usually end with. So you have done quite some zigzagging throughout your career and, moving from even arguing before the Supreme Court and winning, and counseling clients on how to present complex legal issues before administrative and federal courts, and moving in-house. What was something that you've learned from all of your moves, and what advice would you have for other lawyers?
Yeah, it's funny to look back over my career, and also just given that I still don't think of myself as particularly old yet for how far we've gone. I think the advice I would give and the lesson I have taken away is don't be afraid to take risks. Like they ought to be educated risks, like think through your pros and cons and like really understand, why you're making the move and how it furthers where you think you want to go with your career. But at least for me, coming out of law school, I had a vision of what a lawyer was. I understood litigation, so I pursued that. And then as you see more and more things, you see different types of problems, you see inefficiencies, you're like, oh, that could be done better for different reasons, or I didn't like how adversarial litigation was and would rather solve problems a different way, which is what led me to sort of doing regulatory counseling originally at Shopify, to this role where it's like, oh, this is just a wholly different way to conceptualize the world, and I like that. And wouldn't it be fun to see all of the legal issues that come with Web3 and crypto? Since it's not really a field, it's just take all of the legal issues and add them to a new concept. So that would be my big plug to everyone, is really take risks. Very few things like can't be recovered from. So go find something that appeals to you really and try to push that forward for as long as it makes sense. And like, you should always keep your eye on the horizon. Like that's the other piece of advice I give, is I've always looked for the next opportunity, even when I loved what I was doing, because something cool will come along, which is really how I found Violet. It's like, that is just perfectly dead set mission aligned with me. It's like, that's the thing, but you don't know it if you're not willing to translate into a new industry, try really hard things, and grow. You got to always be willing to grow.
Yeah, I think that's really great advice. Like you said, you're going to miss out on things if you're not looking around. So it's always good to be thinking and be deliberate about your career. I think that's great advice for everyone, not even just young lawyers. So before we let you go, one last question. Tell us something about yourself that we wouldn't know if we only knew you professionally.
I love this question as I try to carve out a Twitter presence and my founders keep telling me I need to say something that's not legally related. Elyse would know this, but no one else necessarily would. I am just the largest North Carolina State fan, probably maybe in existence. I'm sure there are some folks in Raleigh who are bigger NC State fans than me, but I have held season football tickets since I was 15 years old. I bought my own right after I graduated at 22. I've driven down for every home football game from when I lived in DC to now. I mean, I just flew there from Miami from a trip, and I'm going to fly back in next week from a different trip to make sure I don't miss a game. So I follow them religiously. They are objectively could get better in some ways. I know, Elyse, you can say it. Clemson won. Then we went and lost to Syracuse this weekend. But I love them completely. So I am just an enormous NC State Wolfpack fan. Go Pack.
Yes, I will say, as someone who has had the pleasure of knowing you personally for a long time, that was a good answer. And we really appreciate you joining us today. This was a really great discussion, and I learned a lot.
Awesome.
Yeah, thank you so much.
It was a real pleasure, Jana and Elyse. Thanks so much for having me. And anyone who wants to talk crypto or human-bound tokens or Violet, feel free to reach out.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.